scope of your investigation to the application of this gadget only. Have you done any research with respect to other jurisdictions or other institutions like UNO, European Community, UN Human Rights? There is a resolution of Human Rights Council, resolution number 34/7 of 2017, that privacy, mass surveillance is inherently disproportionate. So what you have done is inherently disproportionate by international standards. Then there is study and resolutions of European Human Rights Commission also. So we cannot single out this, and you cannot say that you are not surveilling all citizens, only wrongdoers. How can you say that?
Thank you, Your Lordship, for your question. Firstly, I would like to address on the point. I would want to clarify that I'm distinguishing between investment.
No, one more thing. There is a international scenario. There is something called the Johannesburg Principles of National Security. Says that even in national security context, surveillance must be necessary and proportionate. My sister judge asked you, what was the immediacy? What was the urgency? What was the urgency for this? Sidestepping the usual legislative process, making an executive order. Is it not disproportionate? Have the power of a giant, but not don't use it like a giant. What do you say?
Thank you, Your Lordship. On the international position question that you mentioned, so especially in the UN Human Rights Council, it recognizes surveillance is not per se illegal, but must satisfy the 4 points: the legality, the legitimate aim, the necessity, and the proportionality. Furthermore, the UN has also stated that states can conduct surveillance, but must have legal frameworks, ensure override mechanism, and provide remedies against the abuse. So, to address the point on the urgency matter, so the urgency of the project Nigrani must be appreciated in the light of the fundamental constitutional duty of the state to ensure security and public order. So, as articulated in the Hobson's principle, I would like to say that the very purpose of the state is to prevent a decent where the protection of life and security becomes the primary condition for the enjoyment of all other rights. In the present case, the state was confronted with increasingly sophisticated technology-driven threats. So, where additional investigative mechanisms are no longer adequate. So, the assassination of the city police commissioner within a high security installation is not an ordinary crime. It represents a direct assault on the institutional authority of the state. My lord, in such a scenario, the state cannot be expected to respond with outdated tools. The urgency lay in the need for real-time intelligence gathering, the predictive identification of threats, and the prevention rather than mere post facto investigation. So the Constitution does not require the state to remain a passive spectator in the face of evolving threats. Rather, it mandates the state to adopt effective and reasonable measures to secure public safety, even if such measures involve calibrated intrusion to individual privacy subject to constitutional safeguards.
Public safety is these days ensured by application of bulldozer also, by demolishing the living places, houses and all, by the state. Because why I mentioned that case, the state, whatever the state says cannot be taken as gospel truth. State is always at the receiving end. Proceed.
So just at the last, can it be safer to convict a person only based on the digital evidence or the digital data, ignoring the fact that there are no eyewitnesses, there is no weapon, and also there was no intention. Possibly there seems to be no intention. See, to commit a murder, what is more important is the intention. So the only thing that is available is that the digital data, the digital surveillance records that you have produced on the digital evidence, can it be safer to convict a person, or do you think the benefit of doubt has to be given because the other evidences does not support the prosecution case?
Thank you a lot for your question. I'm grateful for the questions that you posed. So to answer that, I would like to say that, my lords, it is respectfully submitted that the conviction is never based on the nature of the evidence, but whether digital or physical, but on whether the evidence taken as a whole satisfy the standard of proof beyond reasonable doubt. So the respondents are not contending that the person can be convicted on digital evidence alone in isolation. Rather, in the present case, the digital evidence forms a coherent and corroborated chain of circumstances which collectively establishes the guilt. My lord, the evidence here is not a single digital input. It is a convergence of multiple independent digital indicators, including facial recognition placing the accused at the scene, telecom metadata confirming spatial and temporal proximity, and supporting investigative analysis. So, I would like to rely on Sharad Birchan Sarda versus State of Maharashtra, where a complete chain of circumstances exclude every hypothesis except guilt. Conviction is fully justified, even in the absence of direct evidence. So, in fact, my lords, digital evidence often possesses a degree of objectivity and resistance to human error that traditional evidence, such as eyewitness testimony, may lack. So the question is not whether the evidence is digital. The question is whether the evidence it is reliable, corroborated, and complete. So at the same time, such evidence is always subject to judicial scrutiny, verification, and challenge, which has been duly undertaken in the present case. So to conclude, my lord, it is not a digital evidence alone, but a complete and corroborated chain satisfying the test beyond reason. If I may. Your lordship,
You can
Please conclude.
My lords, the respondent most humbly prays that this honorable court be pleased to hold the Project Nigrani's algorithmic profiling does not violate Article 14 and 21 as it constitutes the highest expression of objectivity. Secondly, that the digital evidence obtained thereunder is admissible, reliable, and legally sound under the applicable evidence framework. Thirdly, that no violation of the rights of fair trial has been established, that the concurrent finding of the conviction under Section 302 of the IPC be upheld, and the special leave petition be dismissed. My lords, the state has one final simple submission. In the current era, the choice is not between privacy and surveillance. The choice is between accountable technology and unaccountable human discretion. Project Nigrani chose accountable technology. I am obliged, my lords.
Thank you.
Oh, I think there is a rebuttal.
With due permission of your lordships, I would request the teams to begin with their rebuttal and rebuttal rounds, for which each team will be allotted of 5 minutes. At the end of every 5 minutes, I'll be informing.
The council seeks permission to begin with the rebuttal round.
Yes, start.
Oblige, your lordship. My learned counsel has already mentioned in their arguments that Project Nigrani deals with live recording of telephone communications. It traces live recording of telephone communication, I repeat, your lordship. However, the project mentions only the collection of telecom metadata, which deals with information documenting the context of communication rather than the context of message itself. However, live recording of telephone communication deals with the context of the message as whole. This is what imposing threat on the personal liberty and privacy of the petitioner itself, and under the guise of it being a protection of the state, the Project Nigrani violates fundamental rights. Moreover, my learned counsel has mentioned that it does not study citizens' personal information but the anonymous presence or the geographical data in relevance to the data and the facts. Behavioral input and mathematical technological AI predictive analysis is based on a code that deals with input that leads to the generation of certain output. We are not aware of the algorithm as as to what is being fed in that algorithm itself, and how the output is being derived. Third, my learned counsel has also stated that no one can access the data collected under this project until the algorithm allows. Now, we are not aware who all are the persons who will be allowed by the algorithm itself to enter into the data and collect it and to use it accordingly. Along with it, the council stated that offence took place in 2022. However, the facts clearly stated that the offence took place in 2023. Is my learned counsel trying to mislead the court? And the last one is, to correct my learned counsel, the petitioner's entire contention based on the term opacity solely as was laid down. This is vague because, however, our contention is not solely relied on the term opacity, but it is just one of them. We are trying to bring into the light that beyond the guilt is not proven beyond reasonable doubt. There is existence of certain factors that may lead to the acquittal. And my learned counsel has stated that the petitioner demands detailed technical mathematical algorithm to order. But a slight correction, if I may, petitioner is asking for the guidelines only, not the detailed algorithm in order to alter or hack the project itself. The petitioner is asking for the guidelines as to what the time duration of this surveillance will be, what all will it cover, and how the data will be protected. And the same must be ensured to citizen in order to create a balance between right exercise of DPSP and fundamental rights. As it was also laid down in the landmark case of People's Union versus Civil Liberty versus Union of India. It has also laid down that the surveillance measure must have prior authorization, urgency and emergency of doing so, and it must have a limited duration. That is, there must be a limited duration. But Project Nigrani was implemented in 2022 and it exists till date. This long-term surveillance measure requires guideline to stand on the constitutional grounds. With these, the petitioner is their submission.
I request the lawyer counsel to state the last question.
You're not audible.
Am I audible? I request the lawyer counsel again because we went out of the meeting. It's the last question.
All right.
No,
The learned counsel has stated in the arguments that the petitioner demands detailed technical or mathematical algorithm to alter. But a slight correction, if I may, petitioner is asking for the guidelines as to what the time duration will be, what all it will cover, the data will be protected, and how the data will be protected. And the same is ensured to citizens in order to create a balance between rightful exercise of the powers granted to the state under Constitution and the IT Acts, along with the balance of fundamental rights with reasonable restrictions. As it was also laid down in the landmark case of People's Union for Civil Liberties versus Union of India, that surveillance measures must have prior authorization, urgency and emergency of doing so, and limited time duration. However, Project Nigrani do not have any statutory or sunset clause. It was implemented in 2022 and it is operating till date. This long-term surveillance requires guidelines and statutory backing. Please, the council submits their arguments.
With due permission of the lordships, I would like to inform that was the end of 5 minutes. We'll begin with another 5 minutes of the rebuttal round. Sorry, rebuttal.
May I, Your Lordship, may I proceed with answer? Lordship, the petitioner's argument rests on a misconception of how government impose life with mass and with legal opacity. So
I'm extremely sorry for the interruption, but learned counsel, you are not clearly audible.
am I audible now? Am I audible?
Yes.
Okay.
Can you be visible also?
Am I visible, Your Lordships? My lords,
Counsel, I think you need to shift your camera a bit more. Yeah, that would work. Thank you.
Thank you. My lords, the characterization of the project as involving unrestricted live recording is respectfully incorrect. The state's reliance in the present case is confined to telecom metadata and public space surveillance, not the content of private communication. So, live refers to the speed of transmission, not the depth of the data. Project Nigrani monitors the signaling layer in real time. So under section 5 clause 2 of the Telegraph Act, the state is authorized to intercept messages, metadata. The tar hash is the most basic form of message. By choosing to intercept only the metadata in real time, the state is actually practicing constitutional minimalism, using the least intrusive means to achieve the goal of solving the murder. So, my lords, the petitioner's concern conflates data collection with data misuse. So the state does not act on raw behavioral inputs alone. Such inputs merely assist in risk assessment and are never determinative of guilt. So further, the final action is always subject to human oversight and judicial scrutiny, ensuring that no adverse consequences follows solely from automated proceedings. So under section 123 and 124 of the Evidence Act, the state is not required to disclose the source code of a national security tool. Closing the algorithm is
You said that till the entire analysis is completed by the AI, no person will be allowed to interfere with it. Then how exactly will you get to know how exactly will the human interference happen? Like you just mentioned that subsequently the scrutiny would be there. When the entire analysis is placed, only the final result will be placed before them.
Thank you, Your Ladyship, for your question. So, Your Ladyship, with utmost respect, the premise that no human intervention exists until the entire AI analysis is not. So, the system under Project Nigrani is designed as an investigative aid, not an autonomous decision maker. So, the algorithm merely performs data aggregation and pattern identification. However, the outputs are accessed and evaluated by authorized officers. Decisions such as arrest, charge, and prosecutions are taken by human authorities, and ultimately the evidence is subjected to judicial scrutiny before the court of law. So, my lord, scrutiny does not.
Arrest is taking place based on the analysis given by the AI.
Pardon, Your Ladyship.
The arrest is taking place based on the analysis of the AI.
Yes, Your Ladyship. So, the way it has been functioned, so it takes everything into consideration, and then further, my lord,
that even when the AI is being used for used by the advocates, there are many cases where they have given fake citations. A lot of mistakes have been taking place because of the nature of the AI currently. No AI is currently so advanced that you can expect a foolproof analysis from the AI. In that case, how can you, without proper authority, go ahead in a hurried manner and adopt this AI?
Thank you, Your Ladyship, for your question. With utmost respect, the arrest in the present case is not based on AI as a decision maker, but on human satisfaction derived from multiple corroborated inputs, of which algorithm analysis is one of component. So the AI system, I would like to really clarify the role of AI here, that the AI system under Project Nigrani merely performs data processing and pattern identification. It may flag certain individual based on objective parameters, but it does not and cannot order or execute an arrest. An arrest in law must satisfy statutory requirements such as reasonable suspicions and application of mind by a competent officer. So that requirement remains fully intact and is not displaced by the use of technology. In the present case, the arrest was based on a convergence of factors. So physical presence near the crime, as we've already established before, the corroborated telecom metadata and supporting investigative findings. So the algorithm merely assisted in identifying a lead, which was then independently evaluated. My lords, the algorithm may point, but it is the officer who decides and the court that ultimately judges. Therefore, it would not be correct to characterize this as an AI-driven arrest. It is in substance a lawful arrest based on corroborated evidence where technology has only enhanced investigative efficiency.
With due permission of your lordships, I would like to inform that was the end of 5 minutes given for the sir rebuttal round.
With this, we come to the close of the session, I think.
Yes, sir. Now, I would like to inform about the panel for today for the final round of our prestigious second Nyaya Shastra virtual moot court competition. Advocate Kylasanatha Pillay, designated senior advocate. Advocate E.V. Muthu Kumar, advocate on record, Supreme Court of India. Advocate Pravin Kumar Hota, former civil judge and advocate. Mrs. Pragnya S. Patil, Principal of K.V. Patil School of Law, Bangalore. I am Dr. Pragnya S. Patil. I am Principal of Kylasanatha School of Law, Bangalore.
My name is wrongly stated. Madam, my name is
Kylasanatha.
Kylasanatha. We know, we are friends. Muthu Kumar and myself.
Yes, sir. Yes. We've been known for long time.
I'm really sorry, sir.
No. What is in a name? That which we call a rose by that which we call a rose by
Thank them at least for pronouncing my name correctly, sir.
Yes.
I'm really sorry, sir.
No. What is Shakespeare has said in Romeo and Juliet? What is in a name? That which you call a rose by any other name would smell so sweet.
Yes, sir, definitely.
So it was a sweet experience here with
Yes.
Nyaya Shastra's second moot court final session. What is our next agenda?
So one more distinguished guest is yet to be announced.
Yes.
Ms. Jyothi PM, Assistant Professor. We are really highly obliged for your gracious presence on as our esteemed judges. And with this, we come to an end of our session. Thank you, participants, for your active participation.
I think now the participants may leave so that we can have a deliberation regarding the next procedure.
Your Lordship, if we may interrupt, then the participants seek feedback for the same.
No. The results will be announced later.
I think she's asking for feedback, how they can improve themselves.
Yes, sir.
Everybody did well. Everybody gave their best. It was heartening to see put up in such an effort. And to being students, I think you're all students of. We are also students of law. That's a different issue, but I think you're all students studying in college and the universities. It was a very good effort, and personally, it was also a learning experience. There was things that I also learned. I wish you all the best for your endeavors. Just don't, whoever wins or whoever ends up as members of court, take it too much in mind. You have done your best. Just that somebody slightly better. That's it. So all the best for your future.
May I quickly address the participants? We are judging I'm honored to judge the final round of this moot court. And there are only two teams in the final. And you are here because you are, without a doubt, the best. And it was a very exciting competition between the both of you. And regardless of the winner of this round, all 6 of you are winners in at least my eyes, and I'm sure in the eye of my learned esteemed fellow judges. And all of you did well, and I would just say that this is a moot court is just a preparatory ground for your career as an advocate, as a lawyer, as a legal professional. So all of you put your heart and soul into it, and it was really evident from your presentations. I wish you all the best in your career henceforth. There is nothing to add. You're already super good. in whatever you do and present yourselves with respect to the law. Keep doing it, and I'm sure you will meet with success in your career and in your lives. That's all. Thank you. All the best.
I may add to it, definitely each one of you were the best. I really hope that you continue the same and join the profession and contribute to the profession, right? Become advocates. I think you have role models in front of you. Maybe you should take that and join the profession. Be an advocate.
I will add one more word. It is noteworthy that it is an all-woman final. The finals, there is a.
In fact, that is what I wanted to say in my validity. It is heartening to see that all the finalists are all women. When we are talking about lack of representation or underrepresentation of women, it is heartening to see that all the women are, all the panelists are finalists, everyone are women, and they're doing so well. So probably we might actually end up in the future that we will be asking that men are underrepresented.
No, but if there can be 33% reserved in the parliament, why can't there be in judiciary also? 33%.
No, I don't think, sir. I think
It won't be required, sir.
No, it's not. We will be in future requiring 33% reservation for men rather than women.
Truly, I concur.
Yes, such a thing will come one day.
And to confess, in our college or student days, I was not as efficient or proficient as these young girls are. Really hats off to them. And the way, the ability to have managed everything, it was not an easy task to handle this. And I know in each when you were firing lines. Not only the problem, it was all the firing nature. Everyone was firing from all corners and we had to handle it. So all of them did a great job. Congratulations once again. You're already a winner. Take it from you, you're already a winner.
Congratulations. Congratulations to all.
Thank you so much for this season. It was fortunate.
And thanks to the organizers also, Nyaya Shastra. Let it be a movement in our judicial process.
Thank you so much, Your Lordship. It is a pleasure to have you.
Thank you. Shall we leave now?
Yes, please, Lordship. Thank you. Thank you for your gracious presence.
Thank you all. Thank you.
Thank